Welcome back to the Cordell Cordell and Men's Divorce Podcast. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. We continue to bring you the latest information for guys facing divorce before, during, and after, including all things related to family law, modifications, paternities, contempts, you name it. If it's related to family law, we're going to talk about it here during this podcast, and we have done so over the last 8 weeks. I start my podcast off, and this is no different as you are maybe a repeat listener, and that is, don't take this as legal advice. Obviously, the facts and circumstances of your case may and likely would dictate something different than what we're talking about. This isn't an attorney-client relationship. This is educational, informational. We want you to take notes. We want you to take these topics and go seek an attorney. And my advice, as always, is find one who practices exclusively in family law, like we do. We are available for a consultation around the country, including the UK, via Zoom like this. We can do it via telephone. And we can also do it in person where health and safety is a priority for you. And of course, we want you to take advantage of that. You can find us on the web at cordellcordell.com, or you can reach at 866-DADS-LAW. Continue to tune into these podcasts. We'll do this twice each week, bring you information like today with Jarvis Johnson out of our Georgia office on filing first. Welcome, Jarvis.
Thank you, Scott. Good to be here.
Yeah, so thanks for joining. You know, this is one of the topics that I often will talk about in our live seminars when we used to do those pre-COVID. We'd have guys in the audience and we'd talk about filing first. And, you know, no matter where I practice, whether it be in Georgia, Illinois, or Missouri, and I talk to other clients around the country and in the UK, filing first is kind of on the top of my list, not necessarily to kind of encourage the ending of marriage, but really strategically. And that's something, you know, I like to talk about. And I thought, you know, it was a good topic for you to share today. And you can talk a little bit, maybe start us out by talking about how you can kind of freeze the assets and how that would help when you file first for guys who are interested.
Sure. And, you know, I agree. And, you know, as you know, I have conducted thousands of consultations around the country in the years I've been here with Cordell Cordell. And this is, you know, one of the bullets that definitely are discussed there. So beginning with the assets here. Now, oftentimes, and in the two states I practice in are Georgia and Tennessee. We call them in Georgia standing orders. We call them in Tennessee injunctive orders. So when you file for a divorce, typically the court will basically take control of the marital estate. Basically, everything freezes here. And you can't begin selling off assets, buying more assets, you know, moving significant funds, you know, from one account to another, doing things of that nature. And what I find that a lot of guys who may wait to file for the divorce, and they see it's coming down the road there, they'll see things like maybe the underemployed wife or housewife may take all the savings out or half the savings, or, you know, I've had opportunities where one basically drained the business account. All right. So that was definitely, and our guy couldn't meet payroll. And all this happened before the divorce was filed. And the divorce had been filed, and that relief had been granted, the freezing of the assets, then that couldn't have occurred. And if it had occurred, there would have been, you know, immediate action that could have been taken against those orders here. So I really encourage guys to file first so that we can keep those assets where they're at right here. And the other side of that coin is debt. All right. Oftentimes, the wife may you know, begin charging all the charge cards, the Macy's cards, charging everything up and expecting that you're going to pay for all of that debt, during the divorce itself. So we can also file and try to avoid that occurring in these type of situations. So that's why I believe that we stress that particular point, and Mr. Cordell does also in his book.
Yeah. You know, it's huge. We talk about putting a Band-Aid on the spending and just trying to stop the bleeding a bit. I just had this conversation with a consult like you do all the time. You know, I would say if the marriage is over, if you've made that conclusion, then there are a lot of reasons like you just addressed where we need to take action, stop the spending, prevent the dissipation of assets or the draining of a bank account. That was the exact conversation I just had 2 days ago or a day ago about it. So the other thing that's overlooked really is orders of protection. How can filing first kind of help with orders of protection?
Now, Orders of protection, and sometimes they're referred to as protective orders, temporary protective orders in the state of Georgia, domestic violence orders in other states. There's a lot of different names, but think of it just as a restraining order dealing with some sort of domestic abuse here. Oftentimes they're used as what has been referred to as the nuclear option to try to remove the guy from the home, also to begin the custody battle. All right, so include the kids, attach the kids to that so that you have primary custody of the kids and have removed the gentleman from the home. So by filing first, sometimes you can avoid an automatic presumption that that's going to kind of happen here in this instance. It looks to be vindictive if you are filing that. Now, obviously, if the facts are there. Now, if there's abuse occurring, definitely go and that's going to occur and you're probably going to be removed from the home. You did it, you're gone. But if this is a situation where a divorce has been filed and basically a nice work of fiction is occurring down there where your wife has gone down and said, hey, my husband did X, Y, Z, and none of it's really true, the court will look at it and say, hey, it looks to me like the divorce has been filed here and that you're being kind of vindictive in this situation. I don't see all the facts here, so let's let this bear out probably in the family court rather than it bear out right here. So that's something definitely to consider in this instance. Now, legally, you have a right to be heard if it is filed, but if you have that divorce there, there's an opportunity possibly for it to be dismissed or for the judge to definitely listen to your side of the case if a hearing is held.
You know, it's interesting, this society, another thing we talk about is our mobility. You often, now even in COVID, you may have a spouse who's gone to another jurisdiction. They may just be across state lines. You may have border states, those types of things, border cities. Like here in St. Louis, we can just go right across the river in Illinois, 20 minutes away. Jurisdiction becomes an issue, meaning that you may have an opportunity to secure the jurisdiction. You don't want to fight your battle in another city, in another state, where people may have been there for a good period of time, right?
That's correct. Now, as far as jurisdiction is concerned, I have some pretty good examples with that. In Tennessee, where I also practice in the Nashville area, there are a couple of counties there actually where you can file for divorce and select your judge. All right. So filing first not only has determined, where you're going to file, it also has determined which judge you could have, which could mean, tons in these type of situations, because that judge could be more favorable towards maybe a joint physical arrangement or custody, more favorable towards guys, at least listen to our arguments here, and finances wise could be more favorable. So a lot of different things. Now that's more of a rare occurrence of that actually occurring. But the other occurrence is maybe which state, if both states have equal jurisdiction over the possible equal jurisdiction over the divorce, which state you want to go to. Let's look and see, okay, is this one more favorable to me for XYZ reasons? So filing first gives you the chance to strategize and pick which court, so to speak, that you want to play ball in, as long as certain requirements are met. So we definitely tell guys, hey, look, if all things being equal here, let's take a look at this and let's decide where best to file.
Yeah, because it could be an advantage with child support calculations, alimony maintenance calculations. There are all kinds of things that come into play here, especially when you've made the conclusion or reached the conclusion their marriage is irretrievably broken. And that's why I always tell clients, look, time is not your best asset at this point. And a lot of things can happen that can go wrong, a lot of things that can work against you. And I think filing first in that instance is huge.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell & Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
But let's talk a little bit about the presentation of the case, right? If let's say you have bad facts, I've always talked about this at night, that I want to get on to the judge first. I want to tell my side of the story. I don't want to hear every conceivable bad thing that my client has done, whether it's truthful or not. Don't you agree?
I definitely agree. Be the first to file in these type of situations because you will be the plaintiff and our petitioner, which means if hearings are held, then your side will be heard first. And I like to say you can avoid what I like to call the Oscar winning performance on the other side, where you walk in there, your wife, in this case, we represent mostly men. Your wife is as beautiful as your wedding day, and tears are flowing, and you're the big bad wolf in the middle of those tears, by the way. So, I found that, when we are on the other side of that, oftentimes our clients want us to spend a considerable amount of our time, defending their character, and I tell clients, we have a finite amount of time there before the judge, a finite amount of time. If we're the plaintiff, we have a greater opportunity to present our case, to stick to our roadmap and our theory of the case. If we're the plaintiff here. If we're on the other side of that, we will probably have to spend some time rehabilitating your character and maybe throwing off a little bit of our roadmap. And a lot of judges do not like when you go over your time in these hearings. So be the plaintiff, lead the action in that way. And you also, in some jurisdictions, can dictate the flow of when a hearing is going to happen, kind of put the other side on their heels, be their aggressor.
Yeah, judges are, they're human. They have an attention span just like we all do. There's a reason why college courses are limited to whatever be 50 minutes, 90 minutes. I mean, there's just an attention span. You're just going to lose the judge. And if you're second in line and, they're on the stand for 4 hours bashing you, that truth becomes reality, that falsity becomes reality, whatever it is, right? And so I would say you got to get to them first. Tell your story, frame the case. I always have a theme in my cases. I get that theme right out so it sticks and resonates with the judge. And no matter what's said, the judge keeps going back to that theme that they heard first. And so I think that's critical. The other thing I always talk about, and I think, is that I treat this sometimes like a stock. You want to buy low, sell high, except, in bad economic times, let's just take COVID, for example, a lot of people unemployed. We had record numbers. I always suggest to clients, there may be an opportunity. Maybe you've been laid off. Maybe you've taken a salary cut. Maybe your overtime's cut. No more bonuses, no more stock options, whatever it may be. So now's the right time economically, financially, because everything's at the bottom. And so orders may be framed at the bottom. And so doesn't that come into play when you're thinking about filing first?
Yes. So, I have a saying here, divorce low. If you can. And you went right into where I was going to go with that, as far as this year is a prime example of that. We get a lot of business owners who are in here, and they're not the height of their earning. They're making it, many of them, but they're not the height of their earning here. And I say divorce low because oftentimes in these cases, there's going to be some sort of financial disclosure here and the marital estate, and spousal support, alimony could be at play, child support could be at play, and of course, your business, it could be a marital asset that's being valued here as a part of this divorce. So if you choose to do this now, if you know the marriage is over with and you know that you're kind of on the low curve of your earnings, do it now. Do it now. I like to say, they can't take what you don't have. All right. Now, that doesn't mean that you voluntarily, reduce your income. You voluntarily do things. I tell guys that the court possibly in your jurisdiction could say that you have the potential to earn more than that if they see that you're doing a lot of voluntary actions to reduce. But COVID, no one saw this coming. A lot of businesses depressed through no fault of the business owners, actions. So, this would be a good time, or any time when you see your business in decline, to possibly pursue this so that you have less assets on the table, or maybe not sign that next lucrative contract until you've gotten through this divorce action. Go ahead and file, get it out the way. The other side has no incentive to file while you're low. Some do, and we're happy for it, but they will definitely wait until you have rebounded and then go for half of what that rebound is.
Yeah. The thing back in right after 9/11, and then we tailspinned into a recession, I was interviewed by the Wall Street Journal, and they said, many of your guys, your clients, can't afford to file for divorce. And my response was, they can't afford not to file. And that being that they're at the bottom. And judges at that point were being very receptive to the current situation rather than thinking it is a blip in the road, that they would rebound, because there was nothing that was telling the judges or us or anyone in the world that we were going to rebound quickly and produce more jobs. So I think that's a huge opportunity, especially during COVID, is that we know there are businesses, restaurants, retailers, jobs lost, not just temporarily, probably for good. And some of industries will not recover. And so if you're at the bottom, don't wait for a recovery. This may be the opportunity to strike. And so I think, moving on to our, kind of we're running out of time. And the last really thing is, how do you feel about filing first and leading first with a settlement offer?
All right. Now, and that's one of my fallbacks here, because sometimes, in initial consultation, especially, I may have a guy in there. He says, I am not going to file. It may be for religious reasons. So I always say, okay, I understand that and I respect that. But know that if you're not going to be the first one to file here, then try to be the first one to initiate a settlement proposal. All right. I tell guys, especially guys who have been the breadwinner, they know the finances. As I like to say, they have not been handing the check to the wife for the last 30 years, and they know what their mortgage, what their note is. These guys, I say, look, we can work together with you. We can get a proposed settlement out there, begin the negotiation where we want to begin the negotiation. Have a lot of provisions in there that we know, time-tested provisions that you won't know why they're there today, but you will know in 5 or 10 years why they're there. Why don't we begin the negotiation where we want to begin this? We have a great opportunity to get through more of what we want if we do that. If you wait to the other side, oftentimes what will happen is, you'll get a wish list and you'll hit the ceiling and you'll say, I can't do this. But more importantly, the other side, your wife has probably already been convinced that that's probably what she's going to get here. And we're going to spend a lot more time and energy and attorney's fees, let's be honest with you, trying to move her off that position. So if you lead the action, if you lead the negotiation at the very minimum, you have a great opportunity of getting more of what you want.
Absolutely. Well, Jarvis, again, always thanks for your input and your ideas and thoughts, and letting guys know, especially in an area, not just family law, but considerations outside of the law, like filing first. It's a strategy based most of the time, and there are things that we can do by filing first that help, as you pointed out. So appreciate your time today.
Thank you.
We'll continue to bring this to you. So tune in twice each week. You can find the remainder of our podcasts online, our YouTube channel page, as well as our social media. Continue to check our virtual town hall out. You can register for the next one coming up in October, where you can log in, ask questions live of our panel of Cordell and Cordell attorneys, and get answers right then and right there. So continue to submit those, or to register online to get to the virtual town hall. Again, you can schedule a consultation at CordellCordell.com or 866-DADS-LAW. Until next time, have a great week.